Thanks to the Office of Research for inviting me to do this. It's a great pleasure and great honor, and of course to get the Xingwen Fellowship, right, which I appreciate very much. That helps to fund my research. Right. So today I'll be talking about a topic that's important, key in my research agenda, which is about innovation, as well as institutional change in intellectual property rights in China. Right. So my students can attest to that I usually start 5 minutes after the class or within 5 minutes, but this is 10 minutes, so I think it's fair to start. Okay, so just very brief agenda. I actually meant to keep this simple and less of a research-intensive focus because it's more meant for the general public and students and faculty and so on, right? So I'll do a quick overview of the innovation landscape of China using some of the patent studies I have done, and as well as talking about a topic, a recent paper of mine with two of my colleagues, Xie Song Gang and He Wang, right, in the same department, in the same area, on how can we really understand the behavior of firms in China in terms of innovation strategy in response to a shift in intellectual property right? So a change in intellectual property right regime, how does that affect firms' innovation strategy, right? So I'll present the conceptual framework, I'll talk about the findings and I'll discuss it, and then I'll highlight some contributions and implications for policy and strategy. Right. So that will be the agenda. Any objections? Okay, I guess not. So innovation landscape of the emerging market of China, some of my students might have seen a couple of these slides before, but I think this is largely new. I have revised it. So first, it's important, of course, to understand China, right, as the emerging economy, right, in terms of the innovation landscape. This is because their patents has really accelerated, right, I could say skyrocketed over the recent years, and in fact, it has now probably surpassed that of the US, right, in terms of patenting and applications and so on, right. There's one important window for us to observe some of these innovative activities through their patenting, right? So of course, patenting is not the only way we can observe innovation, right? There are other things, right? Kept as trade secrets, kept as other in the companies that they do not, let other people know, and things that we cannot observe. But patenting, by and large, is extensive, right? It stretches over a long period of time, and therefore is relatively stable and for us to observe. Right, so we can use the SIPO patent, which stands for the Patents from the State Intellectual Property Office of China, which is the equivalent of the USPTO, which is the United States Patent and Trademark Office. So the counterpart of SIPO, right? So instead of using the USPTO patents, which many scholars have done before, to have a glimpse of the innovation landscape of China, I think it's important to make use of the SIPO patents as well, right? Because this would mitigate two problems. One is selection bias, because the sample of Chinese firms willing and able to file a patent with the USPTO is severely restricted compared to the entire population of Chinese firms, particularly startups, right? So if you only look at USPTO, we might be only looking at a very narrow scope, a very narrow set of innovations, right? Instead of using the entire spectrum of innovation. And there might be some problem with underrepresentation because for governments, university, research institute, and so on and so forth, many of them largely file only in China and not in the US. So it's again important to look at both USPTO and SIPO. So some of the key findings, so this is a paper based on my research published in the journal Science in 2010. So the key findings is from 85. That's more or less when the SIPO started, right? Application processing of the patents as well as granting of the patents. From 85 to 2006, China's patent system is marked by a growing domestic private sector, scientific and technological capability, and a systematic geographic diffusion of innovative capacity, right? So what do I mean? Right, so if we start from 1.1 million SIPO granted patents, and then we narrow it down to about 200,000 granted patents in the 12 major science and technology areas. So this is the focus of our analysis. And these major science and technology areas, of course, are based on a huge literature. They cover, mostly, life sciences, biotech, biochemistry, as well as ICT, information technology, electronics, semiconductors, microstructural technology, nanotechnology, and so on, right? So these 12 major sectors, if we look at them, and this will be the trajectory, right? So we see that initially we have a lot of patents by individuals, right? Up all the way until the 1990s, right? Then when the private enterprises starting slow initially and then overtaking, right, around 2001 and so on, right? The individuals, right? So this might reflect some of the, and then of course we have universities. I'm still not very used to this little clicker. We have universities here, and we have hospitals and other public research institutes, state-owned enterprises, and so on. But these three are the main ones, right? So, and we see that this might reflect some of the complexity in terms of the technologies enterprises engage in, as well as the reform, right, to encourage more entrepreneurial and more innovative activities by the private enterprises, right? And individuals, again, there's a limit to what they could do, right, in terms of as technologies become more complex and so on. So this is somewhat expected, just that I think prior to this paper, there has been little or no analysis on this, right? And of course, this is one of my favorite slides to show that, in fact, if we look at the diffusion of science and technological capabilities in China, and when I say science and technological capability, I mean, again, focusing on the major S&T areas, we see that within each province, how many % of the patents are in the 12 major areas versus divided by all the patents across China, pretty much, right? So you get a relative science and technology advantage for each of these provinces, right? So you see in 1986, the lighter shades means that they are less, pretty much less advantage, less relative advantage, right? So you see some of the darker shades here in the coastal areas, and then and Qinghai, of course, right? Qinghai is has a lot of military and more secretive Chinese technology development bases, right? In Qinghai somewhere here, and you see it's actually quite dark. Even in the 80s something, they already have developed nanotechnology. So over time, I actually did it year by year, but I just show you 2 years. From 86 to 2006, you see this very gradual spread and evening out of the S&T advantages across China, right? So this is actually quite remarkable, right? Before I did this, I didn't know this will come out, right? But you see that because of gradual spread of also firms moving from the coastal areas, Chinese government's systematic policy to encourage innovation and to push innovation, the innovation frontier, more towards the inland provinces, as well as a number of other factors, in demand and supply, labor costs, and so on and so forth. We see a lot of patents are now actually being filed in some of the more inner regions in China. So you see this gradual evening out of the S&T advantages across China. Okay. Again, for a more detailed read, this is just a quick summary, right? For a more detailed read, you can download for free from our lovely SMU library. Of course, a little bit of advertisement for SMU. The papers, as well as some of the other papers that I might talk about. So turning our focus, so that was a very broad overview of the innovation landscape in terms of patenting, right, in China, in terms of who are patenting, which areas, and so on and so forth, right? So now the main part of this talk would be to focus on the firms, right? So in particular, we want to examine if there is a strong or a sharp institutional shift in IPR. How does that affect firms' patenting and innovation strategies, right? When I talk about institutional shift, I mean something like a major patent reform, right? So China has had 2 or 3 major patent reform so far. One is in 92, the other one is in 2000, 2001, another one is in about 2008, right? So our data set obviously doesn't cover up to 2008, right? So about there, so we are not using that one. So the main interest for us would be the 2000, 2001 patent reform, right? So I'll talk more about the patent reform later on, right? So the motivation for this study is that, under the globalization of markets, this we all know, right? There are many institutions, even in the emerging markets, that facilitate innovations are important for competitiveness. And we observe that instead of using, in addition to using China as a manufacturing base, more and more Western and, of course, domestic Chinese firms are conducting R&D in China, right, using it as an R&D center as well, right? Then, of course, we can talk about, how advanced are R&Ds and how important are the patents and so on. But that's another discussion, right? So the conventional view is that improved IPR institution will increase firms' innovation, right? So this is almost like a given, right? So when IPR institutions improve, when the structures, when the system become better, this should help to foster innovation, right? That's the goal, right, of the government for the patent reform, to align it with international system and so on and so forth, right? So previously, scholars have looked at IPR as one of the most important regulative institutions, right? Institutions as in broadly, right? Institutions. So IPR standard in emerging markets are converging to that of an international standard, right? Actually, surprisingly, U.S. has been also converging towards international standard. U.S. is an advanced economy, but many of its patent rules and laws are actually very U.S.-centric, right? But over time, it has actually converged to international World Intellectual Property Office standard as well. So here, China, over the successive major patent reforms I had talked about, of course, over time had improved its patent standard and is slowly converging its IPR regulation to that of international standard. It's one of the member of the PCT, right, Patent Cooperation Treaty, right? So firms have developed organizational routine and IPR practices under different institutional environment. Imagine if you are a company from US, if you're a company from Germany, you have been very much used to the IPR institutional environment in your home country, right? And then when you set up a new R&D center in China, your structure within the firm don't change overnight, right? So you have been quite accustomed to what you used to have in your home country. Of course, over time you might adapt, right? We'll look at the effect of that adaptation, right? So, but Chinese firms are more used to the transitional economy, transitional markets, and some of the standards, right, that has been slightly more fluid, right, than some of the more advanced economy. Okay, so firms tend to embed themselves in different home institutional environment, and of course, when they move to a new host environment, they would over time might adapt, right? But this is important for underpinning of our study. Okay, previous study have highlighted the importance of institutional conditions and transitions in shaping firms' strategies. Right, so including some of paper from other scholars and my own paper with Fiona Murray of MIT, published in the Academy of Management Journal in 2009. Right, looking at some of these transitions and institutional conditions, again how they affect knowledge accumulation and innovation. So the key research question for this study is, how do Chinese firms react to changes in formal institution or rules? How do they react differently from Western firms, right, who are operating in China? So whether and how the shift in China's formal institutional regime in IPR has an impact on firms' patenting strategy, and whether the change in patenting strategy depend on the variation in IPR quality or enforcement across different regions in China. We look at all the different provinces, right, in China. They're actually quite different, right? Imagine, Singapore is Singapore, right? But surrounding Singapore, there are many countries with different institutional conditions, right? Some are more developed, some are less, right? So is China. It's a huge country, okay? As well as whether it depends on the operational age of firms in China, especially Western firms. Okay, so IPR regime and innovation, right? So IPR regime, as I have discussed before, help to mitigate expropriation problem. Emerging market like China usually have weaker IPR regime, but strengthening it should encourage more innovation, right? So this is more or less a given in the literature, right? So strengthening of IPR regime should encourage innovation, but is there a twist to it, right? So where's the puzzle? Okay, so. And firms, especially Western ones, increasingly conduct R&D in China. So they would like to internalize innovation or obtain long-term strong patent protection, right? Their objective is to protect the innovation, right? Of course, then we can talk about there are actually other non-patenting ways to protect innovation, right? But this study focused on patent. So they would probably seek out the patents with longer and clearer protection, typically, right? Western firms, right? So For example, we have SIPO that grants actually 3 types of innovation. One is invention, one is utility model, and there's design, right? So design is not part of our study because it's a very different beast, right? So we focus mostly on invention and utility model. And of course, strangely, most of the audience sits on this side and nothing on this side. So I have to keep facing here, but that's fine. Okay. So I wanted to walk around, but it would be hard to walk around here. It's the one here. No, it's fine. Don't worry. Okay. So strangely, yeah, never mind. So invention versus utility model patterns, right? Will be the focus. Thank you very much. Will be the focus of our study, right? So what's the difference between invention and utility model patterns? Okay, so this is unique to China and some European countries, but for the U.S. There's actually they only grant invention patents. For China, they grant these 2 types. Invention patents have 20 years of protection. Utility model patents have 10 years of protection, right? So that's one clear difference. Invention patents need to go through an extensive examination and substantive examination process, while the utility model patents do not need to go through that substantive examination process, right? Until recently, when some of the laws have changed, right? The reform, which I'll talk about. Okay. And so in general, we will regard SIPO invention patents as having longer, clearer protection versus utility model patents, right? And in terms of technology, utility model patents could cover, shape, size, technical aspects of invention, and so on and so forth. So in terms of technologies, there might be some differences, but still largely is a firm's strategic choice to choose between these 2. Because utility model patent, despite their less clearer protection, they are usually slightly cheaper and granted faster than the invention patent. So a lot of firms actually file for both types. Sometimes you look at utility model patents, it could have been easily filed as invention patents or vice versa. Okay, so firms would make some sort of strategic choice between filing for the 2, despite some of the differences in technology and so on. Okay. So I promised to take a closer look at the 2001 China patent law reform. So this is our so-called natural experiment, and my student will be very familiar with natural experiment because they have done a lot of exercise on that and been tested in the exam. Okay, so this will be like a natural experiment, meaning exogenous shock, right? A top-down reform, a change that firms would not expect ex ante, right? So exogenous shock, a top-down law reform, and specifically, of course, the law reform is to align China's patent standard with that of international standards, right? And we are very interested in 2 of the things that have been changed. One is the patentability of utility model patent is subject to judicial review, and a search report for utility model patent can be obtained after substantive examination may be required, right? I talk about utility model patent as, you don't have to go through a substantive review, right? But after the reform, company can actually request for that, right? And what's the advantage of requesting for a substantive examination? Because then your utility model patent, once you file, without this substantive examination, someone else could file the same thing, or someone else who had filed utility model patent before would then claim that, oh, you actually have infringed on my patent because you're actually filing the same thing and so on, because it had not gone through a substantive review, right? So people do not know, they are less clear about the boundary of their property rights, right? But now with this, things are clearer, much clearer, and they might be subjected to a judicial review, so meaning the protection might be stronger. Okay. So by the way, feel free to jump in, if you have questions, or clarifications to make, right? Don't be shy. Right? So and the other things, along the line of patent scope, assignee rights, and so on and so forth. Basically, the takeaway is, the 2001 reform had made utility model patent stronger, right? And of course, overall patent regime stronger. Right? So this brings me to the conceptual framework. So our first hypothesis, of course, will focus on whether the strengthening of a previous weaker form of IPR protection, in this case the utility model patent, would have effect on the adoption of such IPR protection by firms, okay, by companies. So property right protection, we talked about these 2 things in detail just now. The judicial review as well as substantive examination, and the regulation on the effectiveness of protection and examination of utility model patent as they are clarified, firms are more likely to file for utility model patents, right? relative to invention patent, right? And the more increase in filing could be due to a shift from innovation that may have been filed otherwise as invention patents, of course, or from those inventions that may not have been filed for any patents previously, right? So they are shifting from, people, they might not decide to file anything, but now the utility model patent has strengthened, so they decide to do it, or they could say, okay, so let me shift some of my invention patent to utility model patent since it has been clarified and strengthened. So our first hypothesis suggests, predicts that the strengthening of a previously weak form of IPR protection, utility model patent in China, could lead to a general increase in adoption of such IPR protection by firms. Okay, so this is a general increase. This is quite expected, right? Nothing counterintuitive or anything. Right? So here comes the more interesting part by looking at the difference between the strategic responses of Chinese and Western firms in China. So we talk about Chinese firms are more adapted to the slightly more fluid institutional environments, right? They are less sensitive to formal institutional change. After all, the patent system only started in 85, 86, right? Versus in the US, it has been around for hundreds of years. Okay. So they are more embedded in informal norms and practices, which are deeply rooted in the traditional Chinese philosophy of Taoism and Confucianism. So we actually go down deeper into the roots, right, of firm strategy and how Chinese people, when they make decisions, they are actually deeply influenced by their philosophical belief, right? So in Taoism, there is no objective within written rule about what's the right conduct, right? Of course, there's a right conduct, but in Taoism, there's no objective written rule. It emphasizes wu wei, right? So action through non-action, right? When you do nothing, it means you have actually done something. Okay, it's quite deep, but yeah. I was going to say chim, but okay, it's fine. Okay, it's quite deep for the international audience. Okay, so action through non-action, naturalness and spontaneity, right? So for example, an example would be The Art of War by Sun Tzu, right? So Sun Tzu Bing Fa is an exemplar of how such philosophical thinking can shape behavioral approach and strategy, right? So the supreme art of war is to subdue the enemy without fighting, right? So you take a city, without fighting, by diplomacy or by other ways. Is the worst way to take a city is by full confrontation, right? Sending the army into a city and kill everybody and burn it down. That's the worst. Okay. So on the other hand, Confucianism does not attach great importance to formal rules, right, and regulation, but emphasizes social norms and codes of conduct as the basis of civil society, right? So in fact, they advocate rule by man, right, 人治, right, versus is preferred to 法治, right? So 人治 is about a little bit about 关系 network, right, in China, which has been extensively studied by other scholars. So 人治 established the role of authority, which is quite heavily emphasized by Confucius, and the 关系 networks in governing the relationship between society members, right? So respect for authority and relationship are important to implement 人治, right, in China. Okay. So these are some of the the bricks, right, that I try to lay on top of each other before I come to H2. Okay. So from the previous slide, right, we can see that Chinese people and firms consider formal legal system for conflict resolution as some of the last resort, right? So it would be better to settle, right, out of court and by negotiation and other means than for full confrontational litigation, right, in court, right? So that's the thing. Chinese firms tend to rely less on formal confrontational legal approach to protect their intellectual assets, but more on informal interventions by authorities, 关系 network and practices, and these are deeply rooted in their philosophical traditions. Furthermore, right, one more factor that kind of enhanced this is that the Chinese market, unlike some of the Western or advanced market in Europe or US, they are characterized by this very complex interdependence among weak institutional forces, right? So this could be, different layers, different bureaucratic layers within a county, within a province, and each layer having different interests. So whenever you need to resolve some sort of IP litigation, you actually have to go through different layers and actually negotiate with different things. The town will have its interests. The provincial government will have its own interests, and they will have the interest in terms of the economy of the whole province or economy of the town or the city, and then so they are actually complex, interacting and different weak institutional forces, right, at play, right, which could enhance the feasibility or probability of conflict resolution through informal intervention, right? So it's not enough to say, okay, I will sue you in court, and that should resolve everything. Usually, that's not the case in China, right? So these are some of the informal norms and practices adopted by Chinese firms, right? On the other hand, we talk about Western firms being quite embedded in their home institutional regime, right, which is strong and rather relatively clearer compared to China. And so they attach greater importance to formal rules, are less embedded in China's informal institutions, and they have developed organizational routines. Again, my students will know firms have developed organizational routines and structures to process information and to develop new products, right? So how did they develop these routines? Based on a lot, to a large extent on the practices and the norms in their developed home institution, right? So they might respond to a greater extent, right, more than Chinese firms relatively, to a strengthening of IPR protection. Okay, so while both Chinese and Western firms would respond, but Western firms would respond more than Chinese firms. So our H2 predicts that upon the strengthening of a previously weak form of IPR protection, the increase in its adoption is smaller for Chinese firms than for Western firms. Okay, so that's the main thing behind H2. Okay, so then we turn to look at some variations across different regions, and then later on variation across age. Right. So again, you saw that map of China, right, with different provinces having very different technological bases and different institutional systems. So IPR law reform, of course, is a law that applies across the entire China, right? But of course, we understand that locally the protection, might be stronger in some of the more developed regions. Not always, but sometimes of Beijing, Shanghai, and more advanced coastal regions, Zhejiang, Guangdong, Shandong, and so on and so forth, right? And they might have more robust IPR system, and this is kind of validated by interviews and other sources. So local courts could be more responsive and effective in litigation and enforcement of IPR dispute and infringement in some of these more advanced coastal provinces. And Chinese firms operating in regions with clearer and better developed formal institutions, they have been there, their headquarters are there over time, they have been there for 15 years. They would then be more accustomed to such environment with stronger IPR enforcement, and relatively to their counterparts in some of the weak, less robust IPR system provinces, they will be less, these Chinese firms in more robust provinces will be less reliant on norm-based approaches using informal institutions, right? So it's all relative. Okay. So we predict that, when IPR is strengthened, the difference in the adoption of this form of IPR protection, utility model patterns, by Chinese and Western firms is less salient for technology developed in regions with higher de facto IPR quality. So in fact, I'm saying that in higher IPR quality regions, the difference between Western and Chinese firm, which we have seen before, are less. Because Chinese firm in these regions might respond more to an incentive, to a strengthening of patent protection. So the difference becomes less. Okay, clear? So the last hypothesis, you might think this will go on forever, but this is the last one, H4. Variation in Western firms' operational age in China, right? So as Western firms, right, they come to China. Some have been in China for 15, 20, 30 years. I think there was one sample, one data point in my data that Western firm has been in China for 50, 60 years. I don't know how, right? Monsanto or something. But okay, so Western firms, some have been in China longer, some have been in China shorter, right? So you would expect that over time, some of these Western firms, because of their longer operational age and experience, would have more opportunities to learn and understand from their Chinese counterparts, the markets, the government, and the business community, right? So then, over time, this Western firm could assimilate and learn from the informal norms and practices by their Chinese counterparts, and be, although this cultural or philosophical origin cannot be transplanted, right, overnight, right? But these Western firms would have more time to cultivate relationship, develop their guanxi as well in China with key stakeholders, right? So many of them, as documented by other studies, shows that some of these Western firms transition from foreign investors and to strategic insiders. So over time, Western firm can in fact better adapt to its informal institution and behave more like Chinese firm in resolving IPR-related conflicts. So a firm that has been around for 3 years versus a firm has been around for 20 years, you see a bit of a difference, right, between the behaviors of these Western firms. Okay, one is more adopted, assimilated. The other one is less. Okay, so we predict that again, upon the strengthening of the weak form of IPR, the difference in adoption of the strengthened form of protection by Chinese and Western firms is less salient for Western firms with longer operational experience in China, because they are then less responsive to a shift in IPR reform, right? So the difference again becomes smaller. Okay. Okay, clear? Okay. So these are the main, conceptual framework, and of course we study this in the context of China, the largest emerging market, but still has relatively weak institution. We look at the IPR reforms over the years, 2001 being the one we focus on and the most significant one in terms of utility model patenting. And we focus on technology developed originating in China. So no point looking at technology developed in the US, right? So we focus on technology developed in China. So these are domestic technologies, but each of these technology, to ensure that is comparable to international standards, we actually make sure that each of these technologies is patented in both China and in the US. Okay, to establish some sort of quality, assurance, right, and to make sure the invention actually passed the bar of novelty, usefulness, and non-obviousness, which of course we study in class as well for my students. So these are in fact transnational patents. I have a couple of other papers looking at transnational patents. So for us, this is an important setting because these kind of iron out some of the selection biases. And so these are transnational patents. And so each of these technologies is good enough to get a patent in the US, right? At least that level. But within China, they actually vary between utility model patents or invention patents in China. So they pass the US bar, but in China, firms decide to choose one of the two strategies. Okay? So this is a strategic choice by a firm to go for either invention or utility model patent, even though they have obtained a US patent as well. Okay. So again, a pretty complex data construction. We started with the entire population of granted USPTO invention patent with China priority, meaning they are invented first in China, right? So they originate Chinese originated technology. Technology originated in China. And to ensure consistency, we did all those things, the matching of US and China patents and so on to compare them. And then we, for this, the main studies analysis, we focus on over 1,000 matching patent diets between 85 to 2008, covering 430 unique firms. It's slightly less because we actually remove many of the foreign firms that are not Western. So we have Chinese firms, so we remove Taiwanese firms, we remove Korean firms, we remove Japanese firms, so that we have a sharper contrast, right? Chinese versus Western. So Western would mean US, mostly Western Europe, Germany, France, England, and so on and so forth, right? So. Okay, so firms and organizational assignee characteristics, we obtain this from various sources, CompuStat and so on and so forth, and we obtain the level of the robustness of the local IPR system from their SIPO annual reports, right? Looking at how many enforced dispute and so on and so forth, right? In each province. Okay, so findings. Right. So what do we find? Okay, of course we find it supported. Otherwise there might be no paper. But you'll be surprised, some papers have most of the hypotheses not supported and still published. So that's fine. But in our case, we are quite fortunate to get pretty good results. So H1 is supported, right? So strengthening of IPR regime in China increases utility model patenting by both Chinese and Western firms. Okay, no surprise there, right? In fact, if it's not supported, I think the Chinese government will be a bit like, oh, we spent millions of dollars reforming this system, but no one respond to our improvement. It'll be a bit, then they might not like it. Okay, so H1 is supported. H2 is supported. So IPR regime shift leads to greater increase in utility model patenting for Western firms than for Chinese firms, right? For the reasons we have hypothesized about. So this is by 2.2 to 11 times. So quite substantial, and the difference is very significant, right? Statistically significant. So a little graph to show that. So these are Chinese firms. They are red. Okay, red, Chinese. So these are blue. So Western firms. So you see before 2001. Okay. So you see before 2001, there's really not much pre-trending, and then 2012 2000, 2001, right, implemented July, and then August 2000, we had a window to control for the year 2000 to make sure there's no, in case the effect is ambiguous in that year. So we see a shock, and then we see like a change in Western firm and versus Chinese firms, slightly increase, but not much trend before the shock, very slight increase after, but you see Western firm really taking off here. Okay. So our second finding, so we look at, of course, the IPR regional IPR system quality as well as the operational age, right? So H3 is supported. Basically, we did a number of different statistical tests, and we find that the difference between Chinese and Western firms will decrease if quality of regional IPR system increases, right? Because of the effect I had explained, as well as difference between Chinese and Western firms in terms of the adoption of the utility model patenting will decrease as the operational age of Western firms increase. We will not be able to show the operational age of Chinese firms because when they are born, they are in China, right? So we can look at the other way, which is the operational age of Western firms. As they increase, the difference in terms of adoption between Chinese and Western firms decrease, okay? As they get more assimilated into the Chinese environment. Okay. So some discussions and conclusions. So we find that, in fact, there is a little puzzle here, a somewhat counterintuitive effect that Chinese and Western firms increase their adoption. So this is given, but they actually exhibit difference in their innovation strategies in terms of adoption. Chinese firms, in general, do not increase adoption of such patents as much as their Western counterparts do. So the difference is large and significant at up to 56 times empirically. So this difference is huge and significant. And the difference in such adoption between Chinese and Western firms in terms of their patenting and innovation strategy is negatively moderated by the level of de facto, meaning what's actually happened on the ground, right? Institutional quality of the IPR system in the region, as well as by the increasing operational age of Western firms in China. So these are the main conclusions. All right. Any questions at this point? Okay. So either have been extremely clear, or okay. So I'll move on to the next one. So we hope to, of course, contribute to the literature. That's the point of the study. So we attempt to provide a new conceptual framework and to identify some of the underlying rationale for Chinese firms' lower sensitivity to formal institutional regime changes, right? It can be from their philosophical differences or from the complex interlocking bureaucratic structures, institutional forces in China. So we try to provide some theoretical and conceptual framework to understand the difference and that characterize Chinese society and its economy. So hopefully this study will contribute to the growing literature, which now really examine the interaction between formal and informal institutions, right? So in fact, our study contribute to this literature as well, because IPR institutions are formal legal institutions, while norms, practices, those are informal. Right? So we see these two actually interacting with each other, and it's important, right? Because policymakers need to take into account of both formal regime changes as well as some of the informal practices to have effective policy making, right? So we also contribute methodologically by looking at transnational patents and to iron out some of the selection effects and so on and so forth by looking at patents that pass the bar in both China and US, and focusing on technology originated in China. So such internationally important and valuable patented assets are important assets to the firms in the face of global competition, because firms don't usually, if it's a good, valuable invention, they don't do it in China only, right? They will patent in the US, they'll patent in Europe, they'll patent in many countries, okay, to enhance the protection, right, across the world, right? So these are important in the face of global competition in terms of the kind of data we are looking at. Okay. So I talk about policy. So policymakers should be aware of that both formal and informal institutions affect firms' innovation strategies, and they should consider them when they are making their policy, right? And both of them have real and substantial effect on the effectiveness of their policy making. Okay. And for strategy, we know that for Chinese firms, it's okay to rely on the informal institution for conflict resolution and so on, But overdoing it may prevent them from accumulating important experiences and developing capability in dealing with formal institutions in the international economy, especially when they go to US to fight a litigation, right? They need to be aware of the formal institutional system, and sometimes, in Singapore as well, right? We are very clear about formal institutions, right? We are clear, our rules are clear, our patent protections are strong, and so on, right? So when Chinese firms go to different countries in Europe and so on, they need to be aware of the importance of formal institutions and some of the nuances I've highlighted in this study. And for Western firms, it's okay to understand their home institutional regime, but it's also important to understand when they are doing businesses in China, right, that they should be acquainted to China's informal norms and practices, because that's their way of life, right? There's a philosophy, right? There's a culture, right? So doing so could yield substantial long-term benefits, right? As they have better knowledge of the innovation strategy of their Chinese competitors, and adopting alternative non-legal and potential less costly strategy to resolve IPR conflicts might be one way to go, right? One option. It's not always fighting a war in the court and dragging it on forever, like Apple and so on and so forth, right? But they should understand some of the more informal approaches that will work very well, right, in China. Okay, so that's the main takeaway in terms of policy and strategy implications. Right. Any questions at this point? Anything at all? Yeah.
Well, do you see a development of formal arbitration
in China? Yeah. So I've talked to a number of lawyers and attended their IPR conferences quite a bit. And so the SIPO officials will tell you that over the years, our enforcement, our litigation has improved more and more. And in fact, you see more cases of litigation, more arbitration and all these things. It's true, right? Across different provinces has increased, right? But if you look at it closely, right? SIPO actually, they have somewhat limited resources, right? So if you actually look at it closely, the number of patents has been, skyrocketing, right? So in terms of the number of cases of infringement, if you divide that by the number of cases of infringement in terms of the number of litigation, actually it has been decreasing. Okay, so it's really on what basis? Because there are a lot more patent application, a lot more litigation. Of course, there will be more infringement, and such cases have improved. I'm not saying SIPO is not doing a good job. I'm just saying that we have to be aware of the nuances. But yes, there's a lot of room for development, right? In arbitration, in strengthening their legal system. This is what they are doing, but in fact they have to be mindful of the behaviors, right? The cultural, philosophical approach, right? The informal institutions as well. Yeah. Thank you. Other questions? So rather long answer, but any other questions on any part of this? You want to ask about my personal philosophy? Yeah, so this is one of my key agenda. So I'll highlight, a couple of things that I'm still doing and working on. So this will be one big part, right? One of my other stream look at the formal developed institution, right? Like the U.S., right? So looking at again effect of IPR on innovation strategies and on innovation behaviors, effect of IPR on knowledge accumulation, on the use of knowledge by companies and organizations in the U.S., right? We have published some papers on that as well. And one of my more recent study looks at the effect of mobility, right? When scientists and engineers, they move across the world, across different parts of the U.S., do their productivity increase? Do their productivity decrease? Right? Do they file more patents? Do they write more publications, and so on and so forth, right? So look at productivity. And a number of other things in the biotech, life sciences space. And here in China, more on how developing markets institution, how technology and innovation will develop in an emerging market or transitional market. Right? So this is one other big stream of research for me. Yeah.
I'm curious, as the gentleman asked about a question.
Sure.
You mentioned that China's patent number has skyrocketed.
Yeah.
But the number of cases actually has dropped.
So the number of cases, let me clarify. The number of cases, litigation and so on has increased, but compared to the huge increase, it's actually, on the average, they are not doing better than before. So if you divide by the total number of cases, right, is actually smaller. So yeah.
So given that the rate of increase is slower
Yes,
than
yeah.
other patterns,
Yes, yes.
so that may be a good sign.
Yeah. So that might be a good sign in terms of the overall. Why do you suggest that might be a good sign?
Oh yeah, I mean, that means to say that people don't violate as much as before.
Oh, okay. Okay. When I say litigation, I meant to the extent they can get caught. So I'm not sure how much of that is actually caught. So how much of that is actually caught by the SIPO officials. So I'm not sure whether people actually violate less or whether it's a resource constraint problem that officials from SIPO simply are limited. You can hire more people, but they are simply quite limited in their capacity to catch every case. But I'm sure over time, things have improved in China. But again, I think it will vary geographically across different regions. So, in some regions, there could be increased incidence of infringement, just some of them are not caught.
And I'm curious that there's so many types. You have this trademark, you have these patents.
Yeah.
So what type
Copyright.
of violation is more rampant?
Rampant. So all these are protection of IPR, right? I will not generalize which violation is more rampant, but I will say patents are more important for technology, especially some of the main technology areas I've highlighted here. So, semiconductors, for example, life sciences, biotech, and so on and so forth. So in the technology space, infringement of patent is quite rampant, right? But if you look at, copyrights, if you look at, music, CD, arts, literature, then it's the other things, right? The copyrights and so on, right? And also there has been a lot of huge cases in terms of litigation in trademarks, right? People doing the trademark of a certain brand in China first, and then people who actually own the trademark in other countries have to try to pay them or try to fight and to get back the trademark and so on and so forth, right? So it really depends on what space you're talking about in terms of the infringement. Does that make sense?
There are some process patents.
Yeah.
And process patent, because the problem in China is that most of the major companies are state-owned.
Yes. Yes.
And process, normally you refer to those
Mhm.
state-owned companies
Mhm.
violate against another state-owned.
Yeah.
Is there good resolution mechanisms on that?
Yeah. So actually, I'm a strong advocate of process patents do not provide as much of a strong protection than product patents, for example, right? Because process patents is very easy to circumvent. And a company, if I'm a small company, I look at a process patent because it discloses how you did it. I just have to, make some changes and so on. I can still get to the endpoint, but I just modify my process a little bit. I might be able to even file for a new patent. So it's relatively easier to circumvent than product patents. And product patents, again, it will depend on the type of industry. If it's semiconductor or ICT, they are more strategic. One patent is of less use, but in life sciences and biotechnology, each patent has really substantive value, right? So a company with several patents can get VC fundings and then would have a greater increase in value, right? Versus in semiconductor, they have a lot of patents, but really it's more of a portfolio war, right? Showing that Apple has, Hong Hai has a lot of patents, HTC, just showing that, this is my space. Don't come into my space, otherwise, I will infringe. I'll litigate against you and so on. So process patents are less, I would say, slightly less effective. And so I'm sure large company, they will do a mix of both process and product patents.
So in this case, so that means the China standard on process patent is very different from the other countries. They're very less strict.
No, I will not say that. So the easy to circumvent is not unique to China. Even in the US, even in Europe, process patents are relatively easier to circumvent. So I think the standard is similar, right? So novelty, non-obviousness, utility, and so on across, whether it's a process patent or a product patent, right? It's just that in terms of the implementation, in terms of patenting strategy, when firms want to copy, process patents are easier for them to circumvent and make up their own process and get to the end point. Does that make sense? Okay. Other questions? Yeah.
I'm sorry. Regarding these informal institutions for IPR conflict resolution,
Yeah.
you mentioned,
Yes.
compared to litigation approach, how effective are they in terms of compensation and time efficiency?
Okay. So sometimes, so two answers. So sometimes it's not a matter of choice as well. Sometimes it's a matter of choice. So sometimes they could be quite efficient. For example, we had one case in our sample when this guy invented some electrical product, and that was heavily infringed by the people in the town, right? So everyone is using the same product. And then of course he felt angry, and then he decided to say, okay, what can I do about it, right? So he was thinking about litigation or some of these informal approaches, but after consulting with the town council and the SIPO office and so on and so forth, they actually decided that actually this product is too important for the town's economy because everyone is adopting it's agricultural electrical products, right? So everyone is adopting this product, and so they said, okay, why don't we form a coalition of some kind? You be the leader. You know, people would come sign up under your coalition, under your group, and then you can jointly develop this product or this technology. They may pay you some fee, some royalty or something, and then this will be resolved. So there's no suing of, of this inventor, suing all the other parties. So this would be, I would think, an effective approach, right? Versus if I were to determine to sue everyone, and that might drag out for a long time, right? And it might be very, very costly. And as you know, the lawyers actually get the most of when there's a big patent war, right? It's always the lawyers. So it would really depend on situations and how. So Guanxi network is important. Understanding of the informal institution is important in terms of deciding what strategies to adopt, right? Yeah. But good question. Very long answer. Yeah.
I'm just wondering, is the operational experience in China for Western firms an accurate indicator of how well they can adapt to China's society?
Yeah. So the assumption, of course, they will adapt to various degrees, right? But I think the assumption here is the longer you have been in China, the more you have been exposed to your Chinese counterparts and to other Chinese firms, and you see how they do their practices, how they do their informal understanding of the informal institution, the better you'll be adapted to, right? But of course, better adapted within these Western firms, there are still varying degrees, right? So some might be a lot more flexible than others. But in general, right, the longer you have been exposed to all these institutional forces and informal practices, the more adapted you might be. Yeah. So that's the assumption behind which is, I think, somewhat valid. If you talk to the companies in Western company in China, over time they would develop their own guanxi, right? Over time they would have seen how some practices are done, right, in China, right? And they would try to fit in, right, to a certain extent. Of course, not, losing on their core value and so on and so forth. There are struggles, right? Google is one example. Struggles between core values and practices in China. Other questions? Anything else? Okay. So, okay, sure, yeah, sure.
I'm curious that actually when you're in China, you'll be surprised on the scale and the innovation of the IT industries.
Yes.
The scale is so broad.
Yeah. And they are very fast, right?
And they're very, very fast.
Yes.
So Westerners always has a problem understanding China in the sense that actually that's one of the most creative industries. Supposedly IPRs to be the most important.
Yeah.
But as you said, in China you have so many informal channels to resolve dispute.
Yeah.
And sometimes they will not rely so much really on the formal IPR.
Formal IPR channel. Yeah.
So do you think that's a hindrance, or do you think that they're just growing?
I actually don't think it's a hindrance. I think government should realize that it's not like, I implement reform and everyone will follow and that's solve all the problems. No, they should be very aware of the unique environment of the company, of the country, right? And trying to implement the best policy. And firms should be aware of that, right? To have the least, the most cost effective, the least costly way of protecting their intellectual assets. Could be developing their guanxi network. Many of the firms have, prominent political figures sitting on the board and so on and so forth, to project image that don't come and try to play a fool and try to imitate. There are many ways actually to go around the informal ways doing this protecting this instead of always going through formal litigation, right? Which is an effective way, but is not the only way, and especially in emerging markets. I think these informal institutions are extremely important, right?
I mean, for existing players, they have no problem. They already
Yeah.
have their networks.
Yeah.
What I mean is that
The
it
new
could be a problem to the new startups.
The new startups.
Or they would just say that,
New Chinese startups or new Western?
Chinese startups.
New Chinese startups?
Or they would just give you money and they say, okay,
Yeah.
if you cannot beat,
Yeah.
you, I invite you to join.
Yeah. So actually, many of the new Chinese startups, some of the founders are serial entrepreneurs. They have been in large company before. They have started several other companies. So actually, they have their own set of networks and they have their own guanxi. So you'd be surprised, some of these startups, they managed to get funding, they managed to start, they managed to get contracts, precisely because they had already developed a certain relationship with the. So yeah, but of course there are startups that kind of face this. If I'm a newcomer into the game, I don't know anyone. One stream of study which I'm currently looking into is this haigui, right? When you are being spent abroad for 20, 30 years, you just come back to China. You want to either start your own company or join an existing company. You might have been born in China, you might know people, but not as much as people who have been there for a long time, right? How do they affect? They have great technical expertise, great skill sets, but how do they affect, innovation? How do they affect the trajectory of the companies? Again, this is a study, in progress, but really it varies to different degrees. I think if you have been spent all your life in China, you have started several companies, you have been in large companies, you might have better networks. While if you have spent 30 years in the US, you just come back to China, you might experience the same problem as like a newcomer coming into the industry. Right? At least, again, this is a very interesting research theme agenda, and it's quite hot right now in terms of doing more work on the things I've discussed. Okay. Does it? Okay. All right. Any other questions? If not, I know I'm standing between you and lunch. So then, if there are no further questions, again, thank you very much for attending the seminar, and thanks to the Office of Research. Any questions, feel free. We can talk offline. My emails is, easily find it on SMU website. I'll invite further discussions offline. And for now, thank you.